Our last case for the January call is Armijo versus Bronson. This is a mini oral argument on the application, 20 minutes per side.
Good afternoon. Mark Ronzato on behalf of the plaintiff appellant. For the second consecutive day, I find myself before you with two very distinct issues and two very important issues and a limited time to talk to you about it. I have briefed, I think pretty adequately, the issue that you just had before you in the Carter case, that is this court's authority. As I've tried to explain in that briefing, this court had both constitutional and statutory authority to do what it did. My client, however, to prevail in this case must also win on the question of whether the administrative orders applied to him. And by the way, I'll waive any self-imposed limitation on me asking of questions. And that's what I'd like to address here first in my limited time, because the question becomes, did the administrative orders apply to this particular situation in which my client sent out an NOI in this malpractice case? Now, what's important to begin with is obviously the language of 2020-3, because 2020-3 conveyed, I think, two messages to any lawyer practicing in this state. The first message was that certain things wouldn't be counted. Certain days would not be counted. Not exactly decided at the time 2020-3 was written, obviously, but certain days would not be counted. But the second thing that it conveyed is that the grace period, if you will, that the court was allowing in 2020-3 was not meant to dissuade people who were ready to file to file. They could, in fact, file. They were welcome to file cases if they were ready to file cases. So on the one hand, the court gave a period of time, extended, if you will, the limitations period. Now, what's very important in terms of my particular situation is what was extended, because clearly commencement dates were extended in the language of 2020-3. But it is also undeniably clear that something else was extended, and that is the language of 2020-3, any statutory prerequisites to the filing of such a pleading or motion. That was directly in 2020-3. That is a clear reference to one of the prerequisites that obviously exists in a malpractice case, the NOI. What happened is that administrative order was enacted or promulgated on March 23. In a couple of weeks later, the governor issued an executive order, 2020-58. That executive order basically came pretty close to mirroring the first couple paragraphs of this court's administrative order 2020-3. And it included that in the language that would be subject to the extension, the suspension, whatever you want to call it, was any statutory prerequisites to the filing of a pleading or motion. That was in the governor's executive order. There was something different, though, that was not in 20-3 in the governor's executive order. And that is the language that was added to it, which said you can still file cases You can still file cases if you want. They copied the language of 2020-3, inviting people to file cases if they could. But then it said, nor does it suspend or toll any time period that must elapse before the commencement of an action or proceeding. That was in the governor's executive order, 2020-58. Now, shortly after that, I believe on May 1st, this court amended 2020-3. It amended 2020-3, and it included the language, which did, in fact, apply in the first couple paragraphs to NOIs, because it said, for all deadlines regarding commencement, we're going to make these extensions, if you will, at that point in time. But it's included and any statutory prerequisites to the filing of such a pleading or motion. So included in the amended version in the first paragraph of 2020-3, as amended, was a clear reference to notices of intent. But what the court did in the last paragraph of 2020-3 is to incorporate the language that the governor had put in her executive order, and he had said, we welcome people, and this no way prohibits or restricts the litigant from commencing, nor does it suspend or toll any time period that must elapse before the commencement of an action or proceeding. So what happened as a result of the way Administrative Order 2020-3 was amended was that the first paragraph said this applies to NOIs. The last paragraph said, nor does it suspend or toll any time period that must elapse before the commencement of an action.
Can you help me back to 2020-3? And while I agree that an NOI is a statutory prerequisite to filing, it applies to deadlines of a statutory prerequisite to the filing of a suit. But there was no deadline in your case because the NOI had already been filed prior to this.
I consider that a misreading of the administrative order, because the administrative order says, for all deadlines applicable to the commencement of any civil or probate type, including but not limited to deadlines from the initial filing or a motion, and any statutory prerequisites to the filing of such a pleading. There is no deadline language in the portion of the administrative order that does in fact refer to NOIs. Now, I know exactly what was going on here without even consulting the governor's office. This court invited people to file cases if they could file them, okay? The original language of the administrative order said, we're going to toll NOIs. There's no question about it. In fact, the governor's executive order, if you look at it, actually uses the word tolling, okay? She's a little bit more explicit. But the fact is the original 2020-3 says, without question, we're tolling NOIs, but we're inviting people to file. This created a serious problem for one group of plaintiffs' lawyers, and that is anybody who does medical malpractice. Anybody who does medical malpractice, because of this court's decision in Burton, is playing with the worst kind of fire if they file a case prematurely. In fact, if you file a case prematurely, I can almost guarantee you the dates can be adjusted in such a way by the filing of a motion, it's fatal. Take my word for it. If you file a medical malpractice case under Burton early, it's fatal. You're dead. You can't correct that error. And the plaintiff's attorneys...
You could correct it, but by the time it's been litigated, it's usually too late, right?
That's correct. Yeah. The motion is not going to be made to dismiss until it's too late. A defendant would be committing malpractice in that situation if they file too early. Okay. So the fact is, you invited people to file, but one group of people couldn't file. Why? Because the first part of your order said the NOI period is not going to expire. Well, if the NOI period is not going to expire, as a malpractice attorney, I can't file. Because if it doesn't expire, I'm filing it too early. What happened in this situation, quite clearly, is that the court told, I'll use the word, told NOIs in the original 2020-3, okay? No, and invited people to file. And med-mal lawyers can't file in that circumstance because the NOI period doesn't expire. The governor's office, quote unquote, solved that problem. She put into it the language that said, oh, but this does not toll any time period that must elapse before the commencement of an action. She left that in, put it in there. This court copied it in its amended version of 2020-3. But what was left for lawyers was the fact that the first paragraph of the amended version of 2020-3 explicitly said, you are, in fact, told with respect to any prerequisite to suit. The tolling, I'll call it tolling, applies to an NOI. But in the last paragraph of amended version 2020-3, the court expressly said it doesn't apply to a prerequisite. Now, there's no question in my mind as to why this change got made. It was telling malpractice attorneys that they could file cases. The fact is that this language in the amended version was telling malpractice attorneys the NOI period is going to expire. You can file your NOIs and the thing will expire and you can actually join the rest of the litigants who are filing cases. But the fact is, the language that was left in the amended version of 2020-3 was language that said this tolling applies to NOIs. That's the dilemma that was faced in this case. Now, what ultimately happens in this case is this court issues 2020-18. And 2020-18 is at the end of the emergency period that the governor has declared. And 2020-18 is the administrative order that's going to announce, that how long this period of suspension is going to take place, of limitations periods. What this court said in 2020-18 is that the period of time of suspension will last from ultimately March 10th through June 20th. And the court explained specifically in how that was going to operate. Because what the court explained in 2020-18 was in essence a tolling effect. I'll acknowledge this. What it said to every lawyer in this state is that right now, as of, I think it's June 12th, that 2020-18 gets passed. What it said was, you look at how much time you had on the statute of limitations as to March 10th, when the state of emergency was declared by the governor. Look at that, find out how many days you had left on the statute of limitations, and that's the amount of time you have left from June 30th. Obviously, I'm paraphrasing, but that's exactly what this court said when it passed 2020-18. Now, what does that mean for my client, or the attorney that represented my client? What happened in this case is that the plaintiff's attorney gets 2020-18. The plaintiff's attorney knows now whatever was left on the statute of limitations as of March 10th is remaining on the statute of limitations as to June 30th. Well, the plaintiff's attorney didn't have much calculation to do. Everybody, by the way, everybody agrees in this case. My opponents here, the Court of Appeals, and us, we agree the real statute of limitations in this case, forget about the court's administrative orders, the real statute of limitations in this case was September 4, 2020. No debate about it. And I've attached a nifty little chart in my brief if you want to check out how it was calculated, but everybody agrees on it. As of September 4, September 4 is the real statute of limitations. As of March 10, when the court instructed people to start making their calculations, there were 78 days left on the statute of limitations, which they agree on. 78 days as to March 10th. Under this court's administrative order, 2020-18, my client had 78 days as of June 30th. That's what this court told plaintiff's attorney in this case. Now, the 78 days after June 30th is December 15th. This case was filed on December 14th. The instructions that you gave were followed closely by the plaintiff's attorney in this case. You told them on June 12th, in an administrative order 2020-18, you've got the same number of days on June 30th as you had on March 10th. We had 78 days by their admission, 78 days. And 78 days.
You're confusing me a little bit. 78 days after, you said June 30th, or is it June 20th?
78 days,
Where's
78
the
days
16
left on the
days?
September 4 statute of limitations as of March 10th.
Oh, I see, okay.
Yeah.
Court of Appeals said you had 16 days, and defendant says you had 16 days. You had 16 days. Is the Court of Appeals says on March 10th, you had 16 days left in your statute
Well,
of
no,
limitations.
that's wrong. The Court of Appeals agreed with us on September 4th as the statute of limitations. I could look at the Court of Appeals opinion. But the fact is, this court has to be, this court has to be aware of what's happened in the Court of Appeals with respect to this issue, because there's another question in this case that's presented because of what happened in Armijo, okay? And that is, the Court of Appeals ruled in this case based on the language that was added to 2020-3 in its amended form, and it concluded that language that said it doesn't apply to NOIs, basically, that precluded the plaintiff. Now, as I've tried to make it clear to you, there was great confusion as to what 2020-3 in its amended form actually told the plaintiff's
Doesn't your
attorney.
client lose if it applies or if it doesn't apply?
Pardon me?
Doesn't your client lose if it applies or if it doesn't
No.
apply?
No.
How do you thread the needle?
The plaintiff wins in this case precisely because I'm telling you that there is a way to read this by the Court of Appeals, okay? But the fact is, this was confusing to the plaintiff's attorney. The fact is, this court told plaintiff's attorney on June 12th when
Are you
it passed.
criticizing our orders? I said, are you criticizing our orders as confusing? I'm appalled. No, I'm just kidding. You disagree with the Hubbard case in the Court of Appeals? You don't like that interpretation?
No,
right?
I don't like the Hubbard case. But you have to be aware of what's happened in the Court of Appeals in my limited time left. Because
Well, that's one thing that's happening is the Hubbard case, right?
Pardon?
That's one thing that's happening, the Hubbard case, right? What other cases? Just tell us what other cases.
Okay, well, you have to be aware of a case that's been decided in November of 2023, okay? Because
What's it called?
this case, after deciding that the plaintiff's case was thrown out because of the additional language that was put into 2020-3 in its amended form, I would suggest the confusing language put into 2020-3. The Court of Appeals said this: because amended administrative order clarified that the notice period continued to run, and because the administrative orders by their language only applied to deadlines which took place during the state of emergency. Now, what has happened in the Court of Appeals as of November of last year is a Court of Appeals panel has taken that language and it has determined that the only effect of this court's administrative orders, the only effect, is if the limitations period expired sometime during the state of emergency, sometime between March and June 30th, March 10th and June 30th. This court has to be aware of the fact that the Court of Appeals in a published opinion has written out of existence what this court expressly found in 2020-18, and that is that you don't count any days between March 10th and June 30th. I'm running out of time, but you have to be aware of the Tolman case. It's not in the briefing because it came out after we briefed.
What's the
But
case?
What's the name?
What's the case?
the name of the case is Tolman, T-O-M-A-N. It was decided on November 21st, 2023, and it basically guts what this court ordered.
Do you have a COA number? A docket number on it?
The Tolman case is, if you're interested, 2023 Westlaw, if you're interested.
Oh, okay, we'll find it.
But it's a published case, T-O-M-A-N. It says, following the stray language in the Armijo case, and it is stray language in the Armijo case, it determined that that was, in fact, not dictum, something that the same judge in the Court of Appeals had reached the opposite conclusion on earlier, in an earlier published case, but okay. The fact is, Tolman guts this court's administrative orders. You've got to be aware of it, because what it says is, when this court said, you have the same number of days left on June 30th as you had on March 10th is no longer true. It is no longer true, because you can have the same number of days, but if your statute of limitations...
Can I just ask you, you're at the end here, if we agree with you, we have to disagree with Tolman, this case that we have, I just don't talk loud enough. If we agree with you, we have to disagree with Tolman, the case you just told us about.
Yes, you better disagree with
And we have to disagree with Hubbard. Are there any other cases we have to, Hubbard also tried to make some
Yes,
sense of
yes.
this order. You don't like that interpretation either, right?
No, I don't like this interpretation. The one that's gotten it right on medical malpractice cases so far is Lindstrom. That's the case that got it right, because it follows how the calculations are done in a medical malpractice case to the T, the way everybody's been doing it for the last 30 years. I must say
Which
that...
case is that
I'm
again?
sorry.
Say that one again.
Lindstrom.
Lindstrom.
We have that.
This case is, however, I concede to you, different from Lindstrom, because the thing that's being told is, in fact, the NOI period. But as I've tried to explain in the brief, and trying to explain to you here today, the fact is that you have to read these the administrative orders have created some amount of confusion in this area. And I would recommend Justice Viviano's footnote 27 in the Browning case as some indication of how this confusion should be resolved. And the point after 17 years, I finally found something worth citing from Trentadue. Trentadue says where there's been confusion created by a court, that there is some equitable basis for adjusting it. And I would really respectfully suggest to you, there's been a lot of confusion created by the amendment of 2020-3. Thank you.
Thank you very much.
May it please the court, Michael Vanner for defendant, Dr. Forsyth. I'm going to abandon my outline and try and jump around and address questions I've heard come up as they go, and trying probably to go in inverse order. My memory of the Tolman case that recently came out is that it is not anything particularly earth-shaking or confusing. I think Tolman said, if we read these cases, Armijo was the earliest in time, and Armijo said, because the tolling orders only apply to deadlines that expire during the state of emergency, they don't expire here. Other cases that have gone contrary to that have disagreed with that, and there's at least one that said that was dicta. I believe what Tolman did was say, we don't think it was dicta. We agree with what Armijo said. We've created a bunch of confusion with these requests for special panels, et cetera, and these disagreeing opinions. We are going to go back and follow the rule that says first in time, so we're going to follow Armijo. I think that's all you'll get out of Tolman. the most critical issue to address when we apply tolling arguments to this case is the fact that the facts of the case make it very clear that there is unlikely any reliance on the tolling orders that went into the filing of these cases. And you have to base that looking at the parties that were named and the procedural history of this case. Noting, first of all, it was filed the day before the statute of limitations ran in Ingham County, which had no connection whatsoever to the case, but was accepting e-filing, so it made it a place one could timely get a complaint out the door. The primary defendants and the place that the medical malpractice that this lawsuit is about, that all occurred in Allegan County. The events in Kalamazoo County were peripheral to the major treatment, and they involved a procedure which put a small perforation through the diaphragm of the abdomen, a complication separate from the primary issue. This lawsuit was filed the day before the statute expires if you give plaintiff full benefit of the tolling orders as to Dr. Armijo. It was more than a week late. It was, I think, 9 days late as to the Allegan defendants, the primary defendants. So, if plaintiff was in fact looking at a filing deadline back in February 14 when the notice of intent was served, and at that point there were 16 days remaining on the statute of limitations, whatever sleight of hand we play with numbers later, as of February 14 when the notice of intent was served, tolling started with 16 days remaining. Tolling expired in August. State of emergency ran during all the middle of that. Plaintiff waited until December to file a complaint, 9 days late as to the primary defendants. One cannot say that that was a calculated reliance upon the tolling orders unless one says it was a calculated decision to file this case with most of it being untimely and subject to dismissal, so obviously untimely that we won't even contest the motion to dismiss those claims. We'll stipulate that we got those wrong. It was so obvious. So there's no equitable reliance on this case. More importantly, I don't think, well, perhaps equally important, I'm not sure how you weigh the importance of any of these. The issue of the tolling orders as it applies to malpractice, I think, is being somewhat misrepresented by brother counsel. He's doing an admirable job to try and create some confusion about the way that the tolling orders apply to NOI tolling. But the vast majority of us out there read the initial orders and did not think that the notice of intent tolling period was put on hold, stalled for some reason. No logical reason to ever think that, because the whole point of notice of intent tolling is sit out, these are inactive days, you just sit and let these days run by in the calendar. In the middle of that, 102 days comes along that we're told sit by and let this run by in the calendar. No one has any reason to think that that affects the notice of intent. So the notice of intent seemed to keep running, but some people apparently were confused, or you would not have issued an amended order. Plain language of that amended order is so clearly a statement that waiting periods are not going to be put on hold. Waiting periods kept on running through all of this. It's so clear a statement on that, to be honest with you, I'm having a hard time addressing plaintiff's argument on this because I don't fully understand how you can read that amended order to say waiting periods like the notice of intent are put on hold and we're not going to continue counting them until next June, because the orders seem to say the exact opposite. Your Honors told us these periods are not stopped. They're not told. They keep going. It was so clear that I'm not sure how you could read it any other way unless it is that you need it to be read that way to render your case timely. So in this case, I think the notice of intent would have kept running all through the 102 days of the statute of the state of emergency. And when the court issued 2020-18, it gave us a rather simple instruction. Look back to where you were at on March 10th. Brother counsel spoke about malpractice and how it works. I've done 98% malpractice for the last 30 years. It's really something I know well. One of the things we know about malpractice cases is that the day you serve your notice of intent, you calculate, I have X number of days remaining on the statute of limitations. And we put 182 days on hold in between then, and we mark on our calendars. Out here in whatever, in this case it would have been in September, your 16 days is going to start running again. So, when the state of emergency came along in March, this plaintiff's attorney should have had, as of February 14, should have had a date calendared. We've got a date coming up in September when this case gets moving again. Then March 10 came along in the state of emergency. And then March 23, I think it was, when your first order came out. And everybody was in a bit of a chaos. And your orders told us, hey, from March 10 on, these days we're going to have some inactivity and deadlines are going to be told. June came along and you told us, okay, deadlines continue to run. Look back at your case. On June 20, if you look at this case, you'd say, on March 10, I had this case on hold because I had 16 days remaining since February, and I'm waiting for September for this case to get moving again. At that point, it's not reasonable for me to say, okay, since on March 10, the notice of intent stopping me or stopped not. That's where I get lost in even how to phrase it. Because the notice of intent meant we're supposed to just let these days go by inactively. If we stop doing that, that can't mean we're somehow being active during those days. What we're left with is, okay, those days were inactive for one reason, 102 days in the middle, we stayed inactive for another reason. Come June, there isn't a logical basis for me to look at this case and say, I had 16 days back in February, but as of March, I had 178 days to go. So it's August, and I thought I had 16, but now I've got till December. That's a real stretch. If that were, in fact, the conclusion that the plaintiff had made or the plaintiff's attorney had made in this case, then we come back to my original hurdle. Why was this case filed 9 days late as to the Allegan County claims? If, in fact, the plan was, in August, I have 178 days remaining. Because if you were counting it right, 172 days as to Allegan, 169 days, I believe, as to the Allegan County claims were actually left. So either their calculation left out Allegan County and they were only trying to get timely as to the secondary defendant, or they never relied on these orders. I have not overlooked the constitutionality question. I'm in a mixed position in this case because I believe that there are serious questions regarding the constitutionality issues. But the NOI tolling question, the double tolling or overlapping tolling, is arguably case dispositive. In one sense, I'm tempted to stop there, but I won't. Unless you have any questions on that issue, feel free to interrupt me at any time. I'm going to spend some time on the constitutionality question. One observation I think we can all agree on is that the tolling orders were issued in haste. We now have had the opportunity to reflect, and we do have time to think about what we've done and what we do next. I think we not only have time to reflect, but I think we have the opportunity, if we do think an error was made, we have the opportunity to change that, to correct that. It's not too late. We don't have to leave a mistake etched permanently in time. Admittedly, any solution I come up with, someone's going to like and someone isn't. It's going to favor someone and someone is not going to like it. But the role of the judiciary isn't to make everybody happy. It's to administer justice. It's to interpret the laws fairly. The task for the judiciary, it's a long-term perspective, And it's a perspective that has to look very carefully at any possibility that we're going to leave an error to stand in our history. If we are concerned, if we do think that the errors may have gone too far, the orders may have gone too far, and obviously I can't make that decision for any of you. I think there is some disagreement, some concern, and some conflict on this question, and it is important for us to reflect on it. It's a relatively small number of cases in the grand scheme of things that would benefit from the tolling of the COVID orders. And so it could be tempting to say, as a matter of public policy, let's just let the system absorb the cost of this. We made an error, we'll correct it, but we're going to let the results of that error stand. I submit that if we do that, we may possibly be creating a much bigger harm. If we believe that the orders went too far, but we do let the results of those orders stand, we are sanctioning those results. We have thus sanctioned a process that, with good intention, issued some orders that we in hindsight think went too far. So what are we going to do about them now? If that is the case, if in hindsight we do have these concerns, but we let it stand, we've created a precedent that an invalid action by this court, which is subsequently revoked, can result in consequences while it was in force that we're again going to allow to stand. I have nothing negative to say about any member of this court whatsoever. I have nothing negative to say about any particular individual that I know of in any justice system that there is now.
Oh, well, thank you. That's actually kind.
But I'm a student
We
of
appreciate
history, and history cautions us that sometimes there may be people in positions of power that we do have doubts about, people that aren't going to act properly, that are going to abuse power. I'm not making this up. I'm perhaps sounding a little grandiose, but it's a well-known fact in history that we're cautious about the accumulation of power. I think it was Lord Acton was the one who said power tends to corrupt. And putting concentrated power in one hand is warned against at great length in all of the Federalist Papers and in all of the founding documents.
I have a question. This is actually very interesting. I'm just trying to understand, though, like, what is the concern as it pertains to the concentration of power and statutes of limitation?
If we allow these orders to stand, Judge Viviano asked if that would require that we have to then overrule Gladich. My concern, and I wanted to find a better way to put this, and I still haven't figured out how, but my concern is that we're overruling more than just Gladich. My concern would be that if we let invalid results stand, we're creating a precedent that we can override the legislature's authority. The ability to establish a time limit is an important part of the ability to create or abolish a cause of action. This is a big inroad on the legislature's ability to abolish a cause of action if we have concluded in this instance that we extended time, we later decided it was wrong, but the extension of time is going to be allowed to stand. That would be a danger. I'm not saying that merely changing statute of limitations deadlines is going to destroy the balance of power. I'm saying it's potentially a big shift because it is a step into the territory that we have traditionally thought of as creating or abolishing. When we put time limits on a cause of action, I think that falls within the creating or abolishing venue. That would be my answer, Your Honor.
Thank you.
So if we are going to let the bad results stand, I think there's a danger that we create a precedent which, in the wrong hands, could be used to issue orders which I don't want to start imagining things, but one could get very creative if one had the power. If we had a precedent that said The Supreme Court may issue a rule and later revoke it, but the results will remain in force. It seems to me the potential for that is obvious. I think that might be why equitable tolling or judicial tolling has always been reserved and used so scarcely. I go back to, and I quoted this somewhere, I think at 1617 of my brief, I quote from Justice Brennan's analysis in Judges for Third Circuit v. Wayne County, where he talks about using the inherent power of the courts only where it's essential to preserve the continued existence or basic functioning of the courts. And in this case, I question whether the tolling orders were necessary to maintain the ability to function, or if it wasn't more, as Justice Brennan thought, provisions to allow the court to operate more conveniently or expeditiously are not an appropriate use of that inherent power. I agree that it would be difficult to implement an order that said, for the period from March 10 to whenever we end it, which turns out to be June 20, in any case where access to the court was restricted, those days shall not be counted. That would be an order that would require case-by-case analysis and would be difficult to implement. But I think it would have been constitutional. It would have fit with the parameters that say we have judicial power over access to the courts, because we'd be limiting the power we're exercising to issues related to access to the courts. So if we could have done that at the time.
You have just 2 minutes left for Mr. Cooper. So I wasn't sure if you were going to.
Any comment?
Mike, I would like to use 2 minutes, but I'll use 1 minute to finish up.
That would be my parting comment, Your Honor.
Thank you very much. Appreciate it.
Thank you.
If it may please the court, I'm John Cooper on behalf of the Bronson defendants. I have 90 seconds, so I'll be very direct. I believe Brother Granzato has a very active mind and an excellent imagination, but I think we should focus in on the precise language of your order and your underlining in that order, the equivalent of judicial shouting, nor does it suspend or toll any time period that must elapse before the commencement of an action or proceeding. You couldn't have said it any more directly. And this fable that the plaintiff's attorney was sitting in his office and confused doesn't bear weight, because if that was true, he would have filed on time as to the Allegan defendants. They were the principal defendants. If he was carefully tracking the days, he would have gone to Allegan and sued them properly. Instead, he submitted it in Ingham County, jurisdiction having no nexus to this case, and he submitted it late. And he didn't intend to omit them. He sued them, and he served them. And then he stipulated to dismiss them. So this world where the plaintiff's attorney was carefully watching his calendar, that doesn't exist. And with that, I thank you for your time and attention.
Thank you very much. Thank you all. The case will be submitted.
All right.